Good morning, everyone. Thank you, Mr. Rao, for that technical discussion on IPR. I think that was very helpful. And I'm really glad to be a part of the panel because the way we've structured is that the first session was on the technical aspects. What I would cover is basically the valuation and the commercial aspect of IPR. What are different valuation approaches that are applicable? And we finally have Greg, who will talk about the practical and legal aspects of the IPR. So very quickly, let me briefly introduce myself. I'm a director in Ernst & Young. I specialize in quantification of damages, claims, and losses in case of disputes, litigations, and arbitration scenario, especially in case of intellectual property disputes. So with that background, we move on to the presentation. This is kind of an overall summary of what we would cover today. What are the triggers for IPR disputes in India and globally? What are different valuation approaches and methodologies that are applicable, which are classified primarily into three: an income-based approach, a market-based approach, and a cost-based approach. And within each of these approaches, there are different methods that can be applied depending on what kind and type of intellectual property we're dealing with. Finally, what are different heads of claims that we notice in case of arbitrations or litigation where IPR is involved? That's the section which talks about claiming lost profits as damages, or computation of royalty rates or price erosion damages. I'll cover the trigger for IPR disputes very quickly over here. So what is really the trigger that I'll give you a live example of a legal versus economic owner of a brand or a trademark or a patent. Typically what we've seen in India, what we've observed is that the technology owner, the legal owner of a technology or a patent, is sitting somewhere in one of the global companies. Now that technology is licensed to one of the Indian companies. Over time, over a decade, when the technology is exploited, it generates huge revenues. It becomes a big brand. It becomes a big trademark. The commercial exploitation of that technology, which happens in India, the Indian company pays a royalty rate or a charge for the use of that technology to the legal owner. What we've seen is over time, there are disagreements between the legal owner and the economic owner of that patent or technology. Because the question comes, who really owns it? Is it the person that invented the technology, legally owns it, the global parent company? Or is it the Indian company which has actually exploited that, sold it, used it, commercialized it, and over the past decade has brought to a level that it has become huge and significant today? So these kind of disagreements or disputes arise from the commercial exploitation of that patent. The second evidence could be a disagreement over the royalty rate itself. So for example, if there is a 3% royalty rate which has been agreed that the Indian company would be paying to a foreign company or a parent company, that 3% royalty rate in today's world, after the commercial exploitation for a period of 10 years, may not appear to be reasonable. So there's a disagreement over the rate itself. And of course, if there is an infringement which has happened, suppose there is a technology or there is a trademark which has been copied by somebody in India, and they are selling off the fake products or counterfeit products. In that case, the claimant would put a claim for infringement of its own brand name or a copyright or a design. So where we come into the picture is that we help the claimants prove and establish that this will be the total quantum of damages that they can bring into the picture in the entire lawsuit, and that can be divided into several heads, which I've discussed in the slide below, that you can either claim the lost profits as damages, basically the entire profits or sales that are made by the respondent, the profit margin that you will generate over the sales made by the respondent using the infringed trademark can be claimed as one of the heads. Or you claim a royalty rate over the use of that technology, and in some cases you can also claim price erosion damages. So we'll cover that in detail in the next slides. Claiming lost profits as damages. In this scenario, the most pertinent aspect is the period of infringement. And of course, this happens in discussion with the legal advisors. So the entire quantification of damages part is always done in line with what is the legal view, which comes of course with the legal advisors. And the second is the company management, the technical experts. As Dr. Rao mentioned, that the entire R&D, the entire merit behind how that patent or the technology or the brand got generated is equally important. So once the period of infringement is established based on relevant evidences, correspondences or supporting documents, what is essential to establish is that during that period of infringement, what is the total quantum of sales that were made by the respondent company using the infringed technology or the infringed copyright of the brand. And this can be done either based on the financial statements of the respondent, which may not be available in public domain. If they are available in public domain, that becomes a strong evidence that during, say, last 2 years or 3 years, which is the infringement period, the company has made X amount of sales. If such information is not available, how do we then arrive at the quantum of damages? It becomes challenging. It becomes a subjective exercise. But what we've seen is that you can create different scenarios. So based on whatever limited market information you have, the brochures that the infringed products talk about, we create different scenarios with respect to the number of units that could be sold. And under different scenarios, there will be a range of the quantum of damages that we could arrive at. And the final step is the profit margin of the claimant. Once you arrive at this quantum of sales of the respondent company, what you are claiming really is not the loss of revenue. You're claiming is the loss of profits that you made on the sales which the respondent made using your technology or your patent or brand. So the claimant's profit margin, which may be healthier or significantly higher than the respondent's profit margin, the claimant's profit margin are applied on the quantum of sales made by the respondent, and this becomes as one of the head of damages, which is lost profits as damages. There is a Panduit test, which I'm sure many of you would have heard. It's a case law. It's a precedence which is typically used in order to prove that entire sales of the respondent can be claimed as lost profits by the claimant. So what this case law says is there are 4 conditions, and if these 4 conditions can be applied in my client's scenario, then 100% of the sales made by the respondent can be claimed as lost profits. What are those 4 conditions? That there is demand for the claimant's product in the market. Claimant has the manufacturing and marketing capacity to cater to that demand. It is not just sufficient that claimant has a demand for the product, but if the claimant company does not have enough capacity to meet that demand, then you cannot claim this head of damage. Third, there are no non-infringing substitutes available in the market. This is very critical. If there are substitutes that are available in the market, this will affect the overall market positioning and demand for the claimant's product, which is condition number 3. And of course, there should be a reasonable benchmark available to establish the amount of profit that the claimant would have made. So these are generally the 4 conditions that are mentioned whenever a precedence is given to the Panduit test. Computation of royalty rates. Royalty rate, as I defined earlier, is a reasonable rate typically expressed as a % of sales below which any award of damages should not fall. So I gave you an example of a foreign Indian company where the Indian company would pay a % of its sales that it made using the technology or the IPR that is legally owned by the foreign company. So in return, they would pay a percent, say 3% or 5% to the parent company of the total sales made. Now, in a dispute or an arbitration scenario, the question comes whether that royalty rate is fair, reasonable, and non-discriminatory, or FRAND as we call it. In order to compute royalty rates which are fair, reasonable, and non-discriminatory, again we use certain precedents which are called the Georgia-Pacific factors. This is again a case law. It's available in public domain. You can make a reference to that. It talks about 15 different criteria or qualitative factors that one must consider while arriving at a reasonable royalty rate in case of any technology or patent. These Georgia-Pacific factors serve as a starting point for determining the reasonable royalty, and they're influenced to a large degree by the presence or absence of substitute either on the demand or supply side. Okay? Price erosion damages. Price erosion damages simply means that if the claimant is a significant brand and its products are selling at a very high price in the market, because its products are infringed, that brand is infringed, the respondent sells those products at a cheaper rate. Because of the respondent using that infringed technology or the brand selling products at a cheaper rate, the price at which the claimant eventually ends up selling its own products gets reduced. Because there is competition in the market, there is a cheaper substitute available, he has to reduce that price. Therefore, in order to establish price erosion, what the patent holder has to prove is the amount of profits that patent holder would have made by selling its product at the higher price, and the amount of profits patent holder actually made by selling its product at the lower price because of the presence of that substitute. The difference between the two becomes my damage that I can claim. So this particular aspect only pertains to the fact that there was an erosion in the original higher price that I as a claimant used to charge because I enjoyed that monopoly in the market, or I enjoy that reputation in the market, which I no longer do because of the presence of fake products or counterfeit products. Now we come to the valuation approaches. Typically, as I said, there are three approaches. There's a market, there's an income, and there's a cost approach. What does the market approach say? A market approach is a process by which a fair value estimate is derived by analyzing similar intangible assets that have recently been sold or licensed, and then comparing these transactions to the subject intangible asset. So this simply says that if I want to value an X patent, or the worth of an X patent, if I want to quantify, I will look at similar patents or similar technology. I will look at any transactions that have happened in the market for those similar patents and technology, and that will help me arrive at a benchmark value for the subject IPR that I'm valuing. Now, as simple as that seems or it sounds, it's difficult to find exactly closely comparable intangibles or intellectual property rights. This particular market approach may be applicable in case of licenses and certain trademarks. However, if you take an example of, say, pharma sector, and maybe Dr. Rao can add more on that, it is very difficult to find a closely comparable patent wherein you can use a market approach and you can apply that market approach on the valuation of your pharma company's patent, because they're very unique. The R&D that goes into it is very unique. Maybe in case of certain trademarks in FMCG sector, such kind of a market approach may be applicable. But this market approach cannot be a primary approach. It has to be a secondary approach which will corroborate the primary approach, which has to come either from income approach or cost approach, because of the challenges that it has. In case you have any questions, once the presentations are over, we can address all of them. Then comes the income approach. The entire income approach basically relies on the fact that there are future cash flows or there are future benefits that are attributable to the subject intellectual property rights. So it talks about exploitation of that IPR in future, and the projected period can be defined as a 5-year period or a 10-year period, and how you exploit that IPR in the long run in terms of cash flows. So here the entire finance theory comes into the picture, where you have the revenue, the cash inflows, all the costs associated with commercialization and exploitation of that IPR, and how do you incur capital expenditure or operating expenses to ensure that certain stream of revenue is guaranteed in future. After you arrive at the net cash inflows attributable in future, you compute the present value or you discount those future cash flows to a present date. This is called a present value concept of the future cash flows, which is an income approach. Now, within this income approach, there are different methods, such as multi-period excess earnings method, wherein if I'm valuing an intangible asset, I will first compute the total revenue attributable for that particular company, and I will deduct from there all the costs that are associated with contributory asset charges, or CAC as we call it, net income less CAC, which is contributory asset charge, which basically means that all the assets that I have in the company, whether it is the fixed assets, it's the assembled workforce, it's the working capital or other intangible assets, I will first deduct a charge on all those other assets. From this net income, whatever is left over or whatever is the excess earnings is the income attributable to my subject intangible asset. The second is a royalty savings approach, which simply says, going back to the previous example, if I have future stream of revenue, I will pay a % of that revenue for the use of technology or brand which I'm licensing from the legal owner. So the present value of those royalty savings will determine the fair value of the brand or the intangible. The third is the profit premium or incremental cash flow method, which basically says that there are two scenarios of cash flows. One scenario assumes that the company owns the intangible. Other scenario assumes that the company does not own the intangible or the IPR. The difference between the two would give you a benchmark assessment of the quantum of that IPR. And finally, there's a direct discounted cash flow method, which is basically all the cash inflows and the outflows associated with the intangible, after which you compute the present value of the same. We finally have the cost approach, which says that the cost approach is based on the economic principle of substitution and price equilibrium. Prudent investor would pay no more for the subject intangible asset or the IPR than the price of that property of comparable utility. So there are two sub-methods within the cost approach. One is a reproduction cost, which basically says that if I have to reproduce this IPR or an intangible, what will be the total cost to construct this internally, which will have the similar properties as the intangible that I'm looking. The second is the replacement cost, which says it is the cost to recreate the utility of the subject IPR, but in a form or appearance that may be different from the exact replica. So it's a reproduction cost or a replacement cost. Software is a typical example, especially in case of IT companies, where people use either a reproduction cost or a replacement cost. Typically, a reproduction cost, in case it's an internally generated software, wherein they would compute the total man hours required to reproduce a similar software, which will then give an indication of the value of that software. Okay, I am at the end of the section with a small case study where I have explained how would you value intellectual property rights associated with a molecule, which is not even commercialized. Okay, so in order to have the commercial angle, the first and the pertinent aspect is to divide the entire phase of that patent into 3 stages, and that will be divided by the valuation date. So we first assess at what point of time we want to quantify the value of that, the value of the intellectual property rights associated with that molecule. See, I'm not talking about the value of that drug. I'm not even talking about the value of the molecule. I am talking about the value of the intellectual property right associated with that molecule or associated with the drug which will eventually use this molecule. So these aspects are very different, because the intellectual property rights, as Mr. Rao also mentioned earlier, it's important not just to create it but also to protect it and commercialize it. And once you quantify the IPRs associated with that particular molecule or patent, that remains with it till the time the patent expires. So we first ascertain what is the valuation date. After the valuation date, we will have to arrive at the financial projections or cash flows during the life of the patent. It is first important to find out what is the economic life of the patent, when does the patent expire, and after the patent expired, how will the projections look like. So prior to valuation date, what is important? Prior to valuation date, it is important to understand the entire technical aspects, where we need help of company technical people and R&D experts such as Mr. Rao. What they would help us in understanding is what are the details of the IPR or the molecule that is being developed. What are the different therapeutic areas or categories that molecule will cater to? What are its strengths? Then what are the details of regulatory approvals that have already been acquired within India or within developed nations? Then what are the details of the development or the regulatory costs that have already been incurred till date? What are the details of the R&D procedure, the overall research that will be carried out, and details of the patent which is registered for the IPR. So prior to commencing the entire exercise, we need to understand all these aspects which are more technical and R&D related, which will help us arrive at the fact that what is really the market that we are looking at. Because see, what we as financial experts would do is put a value to the IPR associated with the molecule. Now, in order to do that, we need to understand which markets the company is looking at where this particular molecule would eventually be commercialized. So we need to find out what the company has in its mind, which are the target market segments that they have, and what is the estimated market share that they are looking at. Once we have this basic information in place, we go to the second phase where we have financial projections during the life of the patent, where the patent has not expired. For each identified market, and here I am specifically talking about developed markets because there are very stringent procedures in terms of commercialization of IPR. So assuming there are 4 phases of development, the initial R&D, the preclinical trials, the clinical trials, and finally the regulatory approvals before the product is launched. There has to be, because I am doing the valuation exercise even prior to a phase 1, for me it is important to assign a probability factor for each phase. Why that is important is because after completion of all these 4 phases, the total cash flows that I will be able to generate would have to be multiplied by this probability factor, because I am valuing the worth of this IPR as of today before it is commercially launched. So first is the phase of development that you can see. Then is the probability of success, which there are various research reports that for a particular molecule in a particular therapeutic area in certain developed regions, what are generally the range of probability success rates. Then what is the cost of development, because in the initial 4 to 6 year period, you will only incur costs because your product has not been commercialized. So it's a long period, it's a gestation period before you start generating revenues. And of course, what is the timeline applicable for each phase? So for phase 1, 2, 3, 4, what is the probability factor for success, that whether this molecule or patent will move on to the next phase? B, what is the cost that the company would incur? And C, what is the timeline? Once you have all these factors in place, after the completion of phase on regulatory approvals, the launch of the product happens. So what is the combined probability factor for the launch of the product? As you can see in the red circle area on the slide, it is T. T is P into Q into R into S, which basically says that the combined probability for the launch or the commercial launch of this IPR is the probability of success for all the four phases, all four phases of development mentioned here. After that, in the bottom right hand side corner, you will see my simple P&L or a financial statement of any company, that this is my estimated revenue year over year that I will generate during the life of the patent. What is my cost of development, which I've already covered in these four phases? What are my operating expenses? Because once the product is developed, you will also need certain operating expenses to manufacture it on a year over year basis. The working capital norms, the capital expenditure norms, all these together will help me arrive at the net cash inflows that I would be able to generate out of this intellectual property right in future post completion of these four phases. Once I complete this exercise over the life of the patent, I simply compute the present value of those cash flows as of the valuation date, which you can see in the top left corner of the slide. As of that date, during the life of the patent, this is the value or the worth of the intellectual property right. Now, what happens after the patent expires? Does that mean that there is no further cash flows that I'll be able to generate? Not really. Because even post patent expiry, there would be a price erosion in the product. The demand of the product would go down because there would be substitutes that would be available in the market. However, I would still have some value coming out of that. So over here, which says financial projections post patent expiry, the right hand side of the slide, we need to estimate the price erosion for the product at the time of patent expiry and maybe 2 to 3 years post that. And why do we do that? If the product was, say, selling at X price, maybe there's an 80% price erosion. So I apply that price erosion to compute the revised price for the product, then the market share which I will eventually have, and I apply a terminal growth rate which will eventually fade out. That eventually I will have a degrowth in the sale of the product. I will still have some value, although may not be significant. In this fashion, we again arrive at the cash flows and we take the present value back to the valuation date. So that was the end of case study. I'm happy to address any questions that you may have on the valuation approaches. Thank you. Greg, all for you now.